Our top story, it's a big win for Aryan Khan at the Bombay High Court. A law student had filed a PIL, that is a public interest litigation, seeking to reverse the clean chit given to him almost a year ago. But the court today has rejected that PIL with a very stern warning for the petitioner. The court has said that the investigating agencies have found no evidence against Aryan Khan. It also asked how the clean chit harmed the petitioner. In fact, the judge was very angry. He called this PIL a publicity interest litigation and not a public interest litigation. Now, if you remember, Aryan Khan was detained on a cruise ship way back in October 2021. He was charged with possession and use of drugs. He spent almost 3 weeks in jail before being given a clean chit. Many people had argued that the case was a classic example of the misuse of central agencies. In fact, opposition parties had claimed that Aryan Khan was being targeted because of his father, Shah Rukh Khan. With this ruling, the Bombay High Court has set the record straight on Aryan's case. The clean chit has been given and frivolous PILs on the issue should be avoided, is what the court is saying. So the court has not taken a very lenient view of this PIL. Let me go straight across to our guest for a very quick chat on our top story this evening. Ravi Rai is a film and television writer. He's joining us on the broadcast. Aditya Pratap is a lawyer and Subhash Jha is an advocate. Aditya Pratap, the fact is that frivolous PILs are a big headache for all high courts and the Supreme Court as well. They are important. In some cases, we understand they serve a purpose. But in most cases, like in this one, it was clearly meant for publicity. There was absolutely no public interest in this PIL that was found, that was filed.
Absolutely. In fact, from the prima facie reading of the news material, it is evident that the PIL filed with the law student was devoid of substance. The very premise of the PIL was weak because under Section 173 of the Code of Criminal Procedure, police officers can submit a report, and if no cognizable offense is made out against the person, they can put him in the not charge sheeted category. So they have the powers to give the clean chit. In fact, the police also have powers to file summary reports also, which I believe was not done, because the summary report you can file A, B, C, or D summary. But of course, that is only if the case has to be closed. In this case, charge sheet was filed, but clearly, if there is nothing disclosed against an accused, person can be given a clean chit by the police. There's no doubt about that. Now, the point is, such PILs, they do end up being a waste of judicial time. In fact, many a time, the courts have observed that meritorious cases do get suppressed. And such cases, and especially because we have PILs in the form of publicity interest litigations, we have PILs in the form of private interest litigations. In fact, there are certain PILs because of which infrastructure projects worth hundreds of thousands of crores are held up, and tens of thousands of crores of escalation comes in. Who's going to pay for all this escalation? So yes, the court has rightly, and remember, PIL essentially seeks a discretionary remedy from the court, because writ is a discretionary remedy, and the court in its discretion can observe that if no substantial cause of action is made out, it can not only dismiss, it can ask the person to withdraw, or it can even impose heavy pre-hearing costs also on the litigant.
Subhash Jha, look at the number of PILs that, for example, just the Supreme Court, I'm not even talking about the High Court here, the number of PILs that the Supreme Court gets. If you look at 2020, more than 50,000. 2019, about 70,000, in fact, more than 70,000. This person who filed this PIL against Aryan Khan and the clean chit given to Aryan Khan is a law student. He should have known better. What was he trying to do?
No, but I beg to differ with the view expressed by the High Court, our Bombay High Court. It appears that try to understand the danger. If somebody has to throw a petition out of the court, it could be thrown out on the ground that you look here, it is a publicity stunt. Now, every petition in that case, so ultimately we are entering into a realm, a very dangerous realm of the judicial system, that we will not possibly, every petition could be thrown on the ground that this is a publicity stunt. Now, when do you call it a publicity stunt? Now, the danger, therefore, what I see is something much more than what meets the naked eye. Please try to understand what is the law so far as pursuing an offender is concerned. Now, granting of summary, I'm asking a question which is slightly basic. Now, would ultimately, if he is rightly or wrongly exonerated, this is a different question. Why was he arrested in the first place? Who will pay, or who will pay for the cost, or rather the cost, the litigation cost? And what about the incarceration which he suffered, the young boy suffered for so many days? Are we not going to hold our investigators responsible for this? Why was he arrested in the first place? Now, coming back to the issue of PILs, now I see a lot of danger. Now, PILs are, how do
Is
we...
the case, if that is the case was, no, the PIL was filed against who? It was filed against the clean chit against Aryan Khan, right?
Correct.
It was challenging that. So what you're saying doesn't really add up. And let me tell you, let me answer your question. This is what the High Court has said. I'm quoting the High Court verbatim. They say the agency investigated. They do not have enough evidence against an accused. In this case, they're talking about Aryan Khan. They gave a clean chit. How is your client harmed by that? What they're trying to ask the law student is, how were you harmed by that?
No.
What is his locus and grievance? Wait, just give me a minute. What is his locus in this grievance? Bhai, aap kaun? Aapse kya matlab? This is what the court is saying. Then they say, as a law student, he should try and file PILs for good causes. You either satisfy us, how does this PIL lie? What is your client's locus? Or we will impose costs. This seems like a publicity interest litigation. So the court is very clear. They have heard this young law student out, and they are very clear that he wanted 15 seconds of fame and he has got it. But the court is not very happy with the way he's got it.
No, I'll tell you what the legal position is. Way back in 1984, a constitution bench of the Supreme Court has said that the doctrine of locus standi is foreign to criminal jurisprudence. Now, that 1984 judgment in A.R. Antule's case had fallen for consideration before the Supreme Court in 2001. And see, just I may read for your benefit of your viewers. To pursue an offender in the event of commission of an offense is to subserve a societal need. Society cannot afford to have a criminal escape his liability, since that would bring about a state of social pollution, which is neither desired nor warranted. And this is irrespective of concept of...
So what are you saying? What are you saying? Is Aryan Khan, what are you saying? Is Aryan Khan the criminal here? Or is the police the criminal here / the NCB the criminal here who arrested him in the first place? So what is the PIL trying to say, sir?
See, ultimately, I have not seen the PIL. I may not comment. But my objection is to the manner in, if at all he was arrested. How did you arrest him without having any material? And what happens to our courts? Ultimately, he had to...
that happened.
Had to travel to the highest court of the state. Matter was argued for a number of hours together. Mukul Rohgi had to fly down from...
Aditya, would you want to come in here?
I mean, this is something which is very...
Would you want to come in here, Aditya? He's saying that there was the argument that Subhash Jha is making on this show is this. He's saying that someone needs to explain to us why, without any evidence, Aryan Khan was arrested. And with this PIL, had the Supreme Court taken it more seriously, had the High Court, I beg your pardon, taken it more seriously, we would have come to know how that happened, and all the people who are responsible for it, example the NCB, etc., then questions should be raised on them. That is the argument that Subhash is making here, Aditya.
Okay. Well, now, with due respect from a learned friend, I'll first take one important line he said. Mr. Jha said that locus standi is foreign to criminal jurisprudence. Taking this as a premise means the law student has the locus standi because he's a citizen of India. He can use the A.R. Antule judgment to file an intervention application in the lower court, and there he can ask for a copy of the entire charge sheet. He should study the charge sheet, and then he can even file a protest petition seeking further investigation against Aryan Khan, saying that these are the lapses in the police investigation, and this is what can be done. The High Court, in its writ jurisdiction or PIL jurisdiction, is not an appropriate authority to go into disputed questions of facts, to analyze verbose charge sheets. High courts prefer to refrain. And third thing, the point is, let's suppose a question comes up that Mr. Jha is saying that the High Court would have been an opportunity to understand who are the people behind the clean chit. But the point is, then you're operating on the presumption that the clean chit is bad in law. So that is something which has to be decided in the trial court. So High Court can never proceed on the presumption that the clean chit to Aryan Khan is bad in law, and therefore High Court should, by way of PIL, inquire into who was responsible for giving the clean chit. No. For that purpose, the law student should have gone to the concerned court, NCB court, where this charge sheet is filed, file an intervention application of there, use the AR Antole judgment, and then make a submission that I seek to intervene. I have studied the charge sheet, and these are the gaps. Please order further investigation under section 173(8) of the CRPC. And yes, again, the ball will go to the investigators to investigate along the lines given by the court, but the court cannot say, fix up Aryan Khan. That the court cannot say.
Okay, Ravi Rai, would you want to come in here? We know celebrities and celebrity kids are soft targets. That is exactly what seemed to have happened with Aryan Khan, arrested without a shred of evidence, spends about 3 weeks in jail and then finally walks out. One had thought the matter was settled till this PIL comes up. Now, yes, the fact is that the High Court is extremely upset with this PIL. They are calling it a publicity interest PIL. They are even saying that this could be a political interest PIL. But should we have expected this, given that celebrities are soft targets and there would be enough crazy people in this country who would not let the matter lie?
You asking me, Shreya?
Yes, Mr. Rai, that question was for you.
Question is to me?
It is.
Can you hear me? Hello, can you hear me?
Loud and clear, sir.
Can you hear me? Can you hear me?
I can hear you. I hope my producers can tell you that I can hear you. Go ahead, please.
Yes, of course. I mean, the celebrities, whether they are cricketers, whether they are politicians, or whether they are the actors, they are always the soft targets. I mean, fortunately or unfortunately, there's a saying that goes, higher the monkey climbs, the more he exposes himself to the hunters. I mean, this is one Aryan Khan we know who went inside 3 weeks because lack of evidences. I mean, even then, there were no evidences. It was lack of evidences. He spent 3 weeks there. And when SIT gives him a clean chit, again, the SIT gives him a clean chit because lack of evidences. Now, if the premise is lack of evidences and you put somebody for 3 weeks, I mean, the boy has a career ahead. You know, the boy has, so I mean, people go through depression, people go through, I mean, their lives can change a huge gear shift can happen. I mean, the NCP, I personally feel that if this is the premise, lack of evidence, then this sounds very scary. I mean, there must be so many languishing inside also. I mean, fortunately, unfortunately, Aryan Khan is Shah Rukh Khan's son. I mean, they could fight out, but there must be so many inside. So I think the probes need to be, I mean, very watertight, and the NCB needs to be answerable. They're responsible for it. You know, you're dealing, I mean, it's constitutionally a breach of, I mean, when you put somebody without lack of evidence, Shreya.
Sure, Mr. Rai, we'll leave it there. Aditya Pratap, thank you very much. And Subhash Jha, thank you very much. Fact is, A, that our courts are overburdened, whether it's the High Court or the Supreme Court. For heaven's sake, spare them these frivolous PILs. And maybe what the court needs to start doing now is actually penalize people who come to them with these frivolous PILs. We'll leave it there for the moment. Thank you very much. There is a piece of breaking news.